Afternoon, Your Honor.
Break today. We also have a few moments to.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor, that would be Mr. Don West.
Someone swear affirm that your testimony these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Afternoon, sir. State your name, please. Occupation? Thank you. And obviously co-counsel on this case, correct?
Yes.
You've been here for the testimony today regarding issues around certain discovery regarding Trayvon Martin's phone.
Certain factual matters, yes.
Brief over.
Yes, I don't.
think the microphone.
Great,
Thank
thank you. A brief overview of the facts that bring us here today. If you would tell us when you first became aware of information resident on Mr. Martin's phone.
Summer of 2012, in that we saw the phone and realized it seemed to be operable and learned that there may be some information available from the SIM card at that point. Early August, I think.
And what was then the next information that we had gotten concerning any information from the cell phone?
I had made several requests to the state for whatever information existed, including any reports. And then I think it was late September, we had scheduled the deposition of the FDLE analyst. And I think it was that day, September 26th, I think, that we were given the report that the analyst had prepared in late March of 2012.
Had we gotten that report before September at his very deposition?
We'd never seen it before.
Moving forward then from September, when was the next time that we had any information or dialogue regarding additional information on the phone?
We were told at some point, and it may have been at the September deposition, that the internal memory, the flash memory, was not accessible, that the phone was locked out, and that efforts to obtain the passcode or the swipe code were unsuccessful. So there wasn't any information at that point that we could expect soon. We learned later in the fall, probably November, December, sometime around there, that the phone had been removed from FDLE custody and shipped to the Santa Barbara Sheriff's Office, I think. We learned all of that after the fact, and that the analyst there was able to ascertain the swipe code. And we made several requests and even, I think, filed some motions, and we finally got that information at the end of the year or maybe early this year.
Was there any additional information that was retrieved or forwarded to us from the California Law Enforcement Agency?
We got a disk around that time frame, I think in late December, maybe January, that was represented to be a data file, but it wasn't of any value. We were told by the state and by FDLE that they weren't aware of any way to process that information into a report form that they had, or that whatever process they were considering would be so incredibly time-consuming that it was virtually impossible. And then at some point around that same time frame, we were told that the company Cellbrite, the software designer to analyze these sorts of things, may be able, at that point, due to some developments in the technology, actually gain access to the internal memory.
At that point, then, had we filed motions in regard to try and get a copy of the underlying data file?
Well, not to be sure that I understand, any underlying data file that existed at that point was either the SIM card, which didn't have much on it, or the data or the file that was retrieved from Santa Barbara, which we were told basically was of no use. We hadn't received any usable data from the phone.
At some point then, did you become aware that the phone had in fact been examined at Cellbrite?
Yes, we were in the loop on that. We knew that the FDLE analyst, Steve Brenton, was planning to take the phone to Cellbrite for an analysis to see if they could get their software to work. And we were told it would be a one-day thing. You could fly up, wait for the work to be done. They would know right away if it was going to be successful, and then return. And we were invited to attend if we could make the arrangements to do that.
And were we able to do that?
No. We were specifically told we couldn't participate, and it would be nothing more than simply standing there and watching.
At some point then, was that move or visit to Cellbrite successful as far as getting any additional information?
Yes.
And what was that?
I think Mr. Brenton went up there January 13th, 14th, somewhere around there. And we were provided, I think within that same week, by the end of the week, with a long report that was the Cellbrite analysis of the data from the flash memory, from the internal memory.
And do you recall the date then of that report?
January 14th, I think.
And to be clear now, is this now the second Cellbrite report that we had received?
This is a bit confusing. There was a short report prepared by the analyst in Santa Barbara, but all that related to, as I understand it, was getting the swipe code figured out. The report we got from Mr. Brenton in September related only to the SIM card, as I understood it, and that the report we got in January of this year was the big one. It was the big one from the internal memory. It was several hundred pages.
Do you now know that to be the report that was testified to earlier as being the 100 meg report as compared to the 3.5 meg report?
Yes, I think I've connected the dots on that.
As we now go forward, we're talking about the February 22nd report as being the same report that Mr. Krudbos testified to was the first report that he had seen?
Not exactly. Not exactly, sorry. We got the first report January 15th, roughly. And then near the end of February, around February 22nd, I believe, we got a second report from FDLE. And that was as a result of communication with the state attorney's office. When we got the report in January of 2013, it did not contain the source file or the bin file that we've been talking about here today. I made requests to the state attorney's office. That we wanted that. I made a specific request to FDLE by email and to Mr. Brenton. And Mr. Brenton responded to me that I needed to address matters of discovery with Mr. Delarionda. I talked with him in some fashion, but I know that by the end of that week, we got the second report, the one that we've been characterizing as February 22nd, 2013. At that same time, we also got the data file. The communication was, we're going to be going to court at the end of this week, and if we're not going to give it to us, then we want the judge to look into it. And by the time we got to the hearing, we had that information.
So we had actually had a hearing set to try and compel the underlying information that week. Is that correct?
I believe there were hearings set, and we wanted the court to address it then. Whether there was a specific motion filed, I don't know, but that was clearly an issue that was being discussed.
Now, there are two reports generated in early 2013, one by Cellbright and the second one by FDLE. Was there any difference in those reports?
I think it's fair to say that Mr. Brenton generated both of them. I don't know if the first one was done at the physical location in New Jersey. I think it was. And then the February 22nd was generated by Mr. Brenton. The only differences that I'm aware of, and I learned this through Mr. Brenton's deposition on February 28th, was some formatting type things that he may have added some cover pages or more personal reporting format, and that there were no significant data changes. It was basically the same report, just looked a little different. The
only changes were facial changes where it had the FDLE logo on the front pages and maybe in the corners of the report pages. Would that be accurate?
That's the way I took it, yes.
No substantive changes or additions to the data or deletions from the data, were there?
Nothing that was identified, no.
And you had mentioned that we had, in fact, set Mr. Brenton's deposition yet again on these issues?
Right.
And that was February 28th, correct?
Yes, I believe so.
Was the state present for that deposition?
Yes.
And without going into all the particulars, was Mr. Brenton questioned about work that he had done or information that was available through and up to date to February 28, 2013?
Well, we were keying off of the February 22nd updated report, which really wasn't any different, as we were told, and that there was no additional information offered, that there had been any significant data recovered, nothing about new pictures or text messages that were previously unreported, nothing like that.
Moving then forward from that deposition, having concluded that, what was the next thing that you're aware of that dealt with any of the reports or information resident on Trayvon Martin's phone?
There was there was sort of a parallel track, if you will, in that on February 22nd, thereabouts, we got the source file or the bin file from FDLE. While the report was substantially the same, we were given no indication that there was new information available or that this report was updated other than by formatting. We did get the source file. So we contacted someone that we thought might be able to look at the source data to see what information was there.
Okay. And there was some testimony earlier about a text message and how that information was available for a deposition in March in Miami. Can you shed any light on the existence of that data?
The reference I heard to that today was some text messages about the acquisition or sale of a firearm. And I believe those text messages, at least, well, there's two conversations that I'm aware of. One relates to a .22 revolver, and one that relates to a .380. That's the reference in the text messages. I believe those text messages may actually have been within the initial report.
Now, did we at some point then learn from Mr. White that there may be concerns about whether or not the state had disclosed information to us that they had available from a download of the cell phone?
Yes.
And did we then decide to file what was then filed on May 23rd as a motion, I'm sorry, on April 30th, let me back off once more, on April 25th, a motion for specific discovery demanding from the state all reports received from any source regarding Trayvon Martin's phone.
It wasn't limited to Mr. White, and I don't have a clear recollection of the initial conversations with Mr. White because I didn't participate in them. But I was personally present at some depositions in April in Miami where a witness testified that she thought some of the text messages were missing from the printout that I had shown her, which raised a question in my mind that I communicated to you. Maybe there's some additional information on the phone that we haven't been provided. And the consulting expert by then had told us he was able to recover some additional information from the phone that was not contained in any of the reports provided by Mr. Delarionda's office.
And then did that lead as well to the April 25th filing of the demand for specific discovery?
Yes.
And was that then heard on April 30th?
I think so. That sounds about right.
And were you present in the courtroom when the court inquired of Mr. Delarionda if he had received any reports from any source, from any person regarding anything having to do with Trayvon Martin's phone?
Yes, I think the inquiry was very specific. That included any information from anyone that hadn't been previously provided to the defense.
And what was his answer?
That they had not received any such information from anyone.
Did this then lead to the filing of our motion on May 23rd regarding the sanctions that bring us here today?
Yes.
Had we received the information in January, the end of January, beginning of February, when it was in the state attorney's office, how would that have assisted us in preparing for trial?
Well, first of all, we didn't get the source file until we made several requests for it. I heard the testimony today that Mr. Quidbus didn't have the source file immediately either, and he obtained it and then did his analysis and discovered all of this additional information, more than 1,000 pictures, I think he said, and deleted text and such by mid to late January, I would think. Well, it's hard to estimate how much time that would have saved us or how prejudiced we would be because we didn't know what we didn't know, and we took great steps to figure that out. And we still don't know, I don't think, because we've never received the report that Mr. Quidbus provided to Mr. Delarionda that I know of.
And by that, are you speaking about the reports that were generated by Mr. Quidbus, both the underlying report and the additional Excel spreadsheet reports?
Right. I know that we spent a lot of time researching and investigating and hiring an expert to see if he could tell us what's wrong with this picture. And we're confident he came up with some of that information. We don't know yet whether he came up with all of it.
And what do you mean by that?
Well, once we got the source file, he was able to do an analysis. And through he's a licensed Cellebrite user, so he had the software. He did not have the same version that FDLE had. We don't know if he had the same version as the state attorney's office. There may be different versions that are licensed to government agencies as opposed to the private sector. But with the version he had, he was able to come up with a a host of information, including photographs and texts and ultimately additional information. So we began to digest that and try to figure out how it might relate to the case. But now we are into March, and we have depositions right around the corner, and we have only a couple of months at that point till trial. So we've just been absolutely overwhelmed.
Can you estimate for the court how many hours additional effort were then spent having to wade through all the information that had to be created that was not given to us by the state back in January?
If we had been provided the report, the expanded report with the source file in January, we, I don't know, 50, 100 hours. It's almost incalculable because it was done over time through the efforts of many people trying to sort this out. We're looking for something sort of like the needle in the haystack.
And you testified before about your hourly rate. Would you remind the court?
$350.
And my hourly rate?
$400. I yet don't know why that is.
Have we, to date, received anything else from the State Attorney's Office or from FDLE in regards to these updated reports?
Yes.
When was that?
Yes. June 4th, I think it was, 2 days ago.
And how large was that report?
In excess of 1,000 pages. And I know that it, as you may have heard the testimony, there are certain bookmarks on the report that identify different aspects of the report, so you can sort of match up the numbers of things. So you can match up the total number of images in the first report, for example, from the second report to then this report. And there are well in excess of 4,000 images, I think.
Have we had an opportunity before today to properly review any of those data on the new report in order to prepare both for trial and for response to any expert testimony that may be presented?
No, we've barely had a chance to scratch the surface on that. We just got it on the eve of this trial. I'm sorry, of this proceeding, which directly relates to that information.
And is this yet another basis for what will soon be filed as yet an additional motion to continue the trial set to begin in 4 days?
Yes, we still don't know completely what's on the phone. We haven't had a chance to review the report and analyze it further.
Do you believe with the time left between now and picking a jury starting Monday that you or I will have sufficient time to review that information, become properly capable to digest it, attend to it, and to get it to an expert to analyze?
And would you include the follow-up with investigation from information that might be in it? No.
The last comment, if you would expound on that. What do you mean by follow-up information?
Information that would then lead to further investigation, whether it would be locating and interviewing witnesses or consulting with an expert about the significance of it.
Such as if we had found a text message on there that said something about a gun purchase, we might have to look into the legitimacy and the foundation for that.
Certainly.
And there's another 1,000 or more images to still be reviewed in that regard?
Yeah, I don't have any expertise, so I don't know the significance of that even. I don't know if it's 1,000 new images or different renditions of old images or where all of that fits together. It's simply information that was effectively dumped on us 2 days ago that we don't have any ability to process at this point.
Nothing further on.
This consultant you hired, who was it?
Richard Conner, C-O-N-N-E-R.
And he was listed as a witness on when, sir?
Listed on a witness list.
When was he listed as a witness?
I don't know the answer to that. Sometime in March, maybe early April.
I'm sorry, March or April?
I would think so.
And how many times have we contacted you or your office or Mr. O'Mara requesting a deposition of that witness?
I don't know the answer to that.
Would you agree that more than once?
Mr. Connor is on the list of people that you have coordinated with us for depositions, yes.
And to date, we have still to receive a report from Mr. Connor. Is that not true, sir?
No, I don't think that's completely accurate.
You've provided us a report of Mr. Connor, what he did?
Yes, in a way. And
Tell me where that report exists so I may find it.
sure. In our discovery, reciprocal discovery, it included reports that he prepared of some of the information on the phone. It was provided to you in several formats.
When was that? Because I'm not aware of us receiving a report from Mr. Connor regarding telephone, victim's telephone.
I'm not sure what your question is. We provided it to you as part of our reciprocal discovery. It was electronic.
When was that?
There's a notice in the court file of when the discovery was filed. I think it was probably in the last 2 or 3 weeks, but I don't know
I'm sorry,
precisely.
in the last 2 or 3 weeks that you did something? Is that what your statement is, that you provided us a report of Mr. Connor in the last 2 or 3 weeks? So you're saying in May you provided that to us?
Well, the report consisted of an analysis that's reduced to a PDF file or to an Excel spreadsheet that contains information. There were a number of those provided to the state as part of our reciprocal discovery. And I think whatever the date is that it was filed, and it was in the last 2 or 3 weeks.
In the last and is there any reason why you waited until the last 2 or 3 weeks to provide that to us?
Not specifically. It was part of the ongoing discovery. We've been exchanging discovery.
Was it intentional, since you had hired this witness in March and he found some documents? Did you wait until now, the eve of trial, to disclose it?
Not for the purpose, I don't think, that you're suggesting.
Well, why did you wait so long to disclose it to the state?
The work was ongoing, and we had reason to believe that the state had information that it was withholding, and we were, frankly, spending a lot of the time that I was explaining here trying to get to the bottom of it and figure out what exactly your office had done. And I think we finally figured that out, and we filed our motion, and we consulted with our expert, and he confirmed that this information was on the phone. What we don't know yet is all of the information. Assuming for the moment it's in Mr. Brenton's report from 2 days ago, we haven't even had a chance to address that.
Yes, sir. My question specifically, do you recall what the title of, or the term that was used to describe Mr. Connor's report?
It wasn't.
Was it labeled?
It wasn't labeled specifically Mr. Connor's report. Do
you recall the phrase that was used to describe it?
To the best of my recollection, the electronic file folder that contained his work, that were the various reports that he prepared, including some Excel spreadsheets and some PDF files. It included some data that he had recovered that then turned out to be additional text messages and some Facebook and that sort of thing. I believe the folder that was provided to the state was labeled R. Connor, for Richard Connor.
Okay. And you believe that was 2 or 3 weeks ago?
Mr. Dillon,
I'm just asking if you don't remember, that's fine. I think you stated 2 or 3 weeks ago.
We had a couple of discovery disclosures. As you know, we've been bumping up against deadlines for quite some time now. And it was around the time that we filed a couple of discovery disclosures in the same week, if I'm not mistaken, or within a few days of each other. Some of them were some of the photos, for example. Some of them were text messages. And we provided your office with a copy of unredacted information.
Yes, sir. Do you believe it was in the defendant's second supplemental discovery or third supplemental discovery? Because I'm not seeing it. I apologize. Maybe it's right in front of me.
Can I have a moment with Ms. Count, because he has it right here in front of him, maybe I can
Do
point
you
it
have
out to him.
Sure, I'd be glad to.
See these right here?
Yeah.
Under C.
Okay. So it's not titled Connor. It's titled Trayvon Martin Extraction Report, 10 pages. Trayvon Martin Extraction Report, 2 pages. I'm sorry, 1 page, 1 page, 4 pages, 1 page, 2 page. Is that what you're referring to? 1 page and 2 pages. Is that what you're referring to?
I can't say that I am referring to that specifically because I'm not looking at it, and
I'll be glad to show you if I may approach it.
I don't think I signed that particular document.
This is the one your co-counsel, Mr. O'Mara, said.
You know, I can't speak to that specifically, whether that's exactly it or not.
So by looking at it, even you can't say whether that is the document or not. Was that intentional on that part? You weren't trying to hide anything, were you?
We gave the electronic file to the state that had all of the information. That's a summary, and it's almost sort of a roadmap. You just look at the evidence. That's when we get CDs and photographs, we look at them. And
I apologize. I didn't see CDs in discovery. I'm
talking about reciprocal. When your office provides us with CDs, we look at them. And when it's provided with photographs, we look at them.
So you're looking at the source, basically. You're looking at the source and then asking us to look through it to determine what's in there, basically. Right?
We provided, are we talking about information that Mr. Connor was
Yes, sir.
ultimately able to extract?
Right.
That was provided to the state in our supplemental
In
discovery.
a source, and then we had to look through it and determine what was there or not, right?
You just look at it. It's
Okay.
there.
Well, isn't it true that the source file regarding Mr. Trayvon Martin's phone was provided to you? I think you stated in February, January? Wasn't all that information there?
Here's what happened on that. We got the report in January. Mid-January, Mr. Brenton got back from Celebrate in New Jersey. And we did not get the source file.
You got it in February?
Then we asked for it, and we didn't get it. And then I wound up writing an email to Mr. Brenton, said, give us the source file, and he said, talk to Mr. De La Rianda.
Right.
I did.
And you ended
then
up
we
getting
got
in
it.
February.
Excuse me, I'm having a hard time hearing. Mr. O'Mara, can you pass notes?
I apologize, I was just trying to get him the discovery that he says he doesn't have, which was forwarded.
I just am asking if you have anything to go ahead.
You got it in February at the latest, the source file?
We got the source file, and I believe the date is February 22nd.
Yes, sir.
Along with Mr. Brenton's second report that was substantially the same as the one in January.
Okay.
There were no significant differences. So we were not told, oh, by the way, we have all this other stuff that we found, all this other stuff that Mr. Brenton was going to be asked to provide. We got nothing. We got the same thing and the source file that was of no use to us whatsoever until we hired our own expert.
So your own expert actually found it there, right? It was in there. Your expert found it, and you had received it in February. You're saying just you didn't know how to look for it until you hired your own expert, right?
After we got the source file, we hired an expert
Okay.
to take a look at it, and he did. And he started to find things that were not in the report.
Okay.
A lot of things.
Yes, sir.
And then we started wondering what's going on here.
But the evidence was in there, is the bottom line, in that source file, correct?
There is one source file, as I understand it. Some of the information is readily accessible, and some of it isn't.
Okay. You mentioned that you were aware, I think you corrected Mr. O'Mara, you were about the guns or the talk about guns in the initial report, correct?
That's my recollection. There were some text messages about guns in the first report.
So you had the actual data as early as February.
There was a picture of a gun, the description of the one, the hand on the gun on the bed, all of that was not, none of that was in the January report. None of it was in the February report that FDLE prepared. It wasn't until much later that that was discovered. And in fact, we know from Mr. Quidbo's testimony, he discovered it in January.
You're saying that you did, when it was right in front of you, you didn't see it because you didn't know how to look it up. You or your expert didn't know how to look it up.
I'm not sure what you're asking me.
You hired an expert who is, I'm assuming, qualified to look this stuff up, right?
Mr. Connor is licensed with Cellbrite.
Right. He knows how to work it from Cellbrite, right?
He is licensed by Cellbrite, and he uses the most current version that's available to him as he explains it. Once we finally got the source file and gave it to him, he began an analysis, and that's when he started finding all this other stuff.
Right. And you consider what the information that Mr. Connor did for you all to be work product, correct?
We provided it to you in our discovery.
Did you provide the reports that he did?
Yes, that's what I was telling you that we gave you in discovery. Those are his reports.
This is what Mr. O'Mara says is the third supplemental discovery, which was done on May 23rd, which you don't know if it is or not because it's not clear, but Mr. O'Mara represented that it is, the one I just showed you.
If you will show me the electronic file, I'll identify for you what I'm talking about.
Okay. My question is, at some point, you guys decided to disclose it. You waited, 6 months to wait until disclosing it? Why did it take so long to disclose it to the state? And my question is, should we be asking for sanctions for you all for waiting until the last minute to disclose it to us? Well, you don't think it's a fair trial for both sides?
I'm not laughing because I think this is funny. This is far, far from amusing.
Let me ask you this.
We
sir.
caught you hiding the information and confronted you about it, and you never gave it to us. And we called a witness today to prove that you hid that information and then misrepresented it to the judge.
Sir, with all
That's
due respect,
okay?
Sir, I with respect to the court, I'm not going to get into a banter back and forth, but I have Mr. Brett here who can explain everything, and he'll be testifying to refute your allegation because it's very good for us to make assertions or allegations without
Is this a question, or are we in fact
I
answering?
apologize, Your Honor, I apologize. My question is, sir, we have a pending motion to compel discovery where you refused your own expert, who you told, I'm assuming, or he stated not to write a report, sent you an email with documentation as to his findings, and you refused to turn it over to us in discovery because you said it was work product.
That's just not true.
You didn't have a dialogue with Mr. Manti and emails where he's requesting documents of your experts in terms of report. You said he didn't do a report, and you said it's work product because he just emailed me the information?
It's going to take me a minute to sort that out. Mr. Manti asked me for reports of experts that relate to the admissibility issue on voice identification.
Yes, sir.
That's an ongoing dialogue that we had, and I don't remember who filed the motion, but there's a motion on that issue, yes.
There's a motion to compel.
It has nothing to do with Mr. Connor that I can think of. That's why I'm having trouble understanding.
I apologize if I confused you. I didn't mean to imply Mr. Connor. I apologize if I misspoke as to that. My question is, we have been asking for documents from your experts, and you said all your experts, they don't do reports, right? Mr. Connor didn't do a report, did he? Did he do a formal report?
Mr. Connor prepared reports from his work on the phone. I guess you might call them extraction reports, and that we provided those.
Okay. Do you recall, I guess going back to Mr. Connor, when he prepared that report? Extraction report, whatever you want to call it. Would the date be on the extraction report?
It was never a single report that I understand. My insight into what he does and how he does it is somewhat limited. But once we got him the source file, he began to process it. And he got information that was previously unknown and began to tell us about some of that.
I guess my.
And that started in March.
Okay.
Yes.
And you guys waited 2 months to provide that to us? Is there a reason for that?
Yes, there's several reasons how all of that transpired.
Okay. My question, sir, is as part of your obligations under discovery, you're supposed to respond within 15 days, 20 days. You haven't completely complied with that. Isn't that true?
No, we haven't complied in that, regrettably, discovery is still ongoing in this case to this day.
Right. And you do recall that the state filed a motion for you to comply, and then once the state filed the motion for you to comply is when you bombarded us with 2, 3, 4 reciprocal discovery finally. Do you recall that?
I'm sorry, I'm having a hard time connecting it with what we're talking about, but did we file reciprocal discovery? Yes, we did. We filed a good bit of it recently, yes.
And was that on purpose?
It was as a result of the ongoing process and some deadlines imposed by the court and late discovery by your office and, frankly, matters that are being litigated here today. It's all part of that, yes.
So it's a normal thing as part of the discovery for that to occur is what you're saying?
I'm not saying that. I'm
Okay.
saying if you're asking me to make a broad, sweeping statement like that.
Only
no.
in this case did it occur, you're saying?
It, meaning what?
Late discovery by the defense on the eve of trial.
No, I think discovery is ongoing, and it's not uncommon for there to be disclosures up until the point of trial. The problem then becomes, what do you do about it?
Okay.
And we got this information from you 2 days ago that we barely cracked the lid on.
Okay, well, are you aware how that came about?
Not unless it's something other than what I heard here today.
Okay.
I heard what was said about it today.
Okay. Then I'll leave it for Mr. Bretton to testify about it. I don't want to. So are you saying that when you're an employee of your office prepares a memorandum, that is not considered work product? When he reviews something and makes an analysis of it, that is not considered work product?
It may be partly work product.
Okay.
Some of it may not be work product if we choose to disclose the evidence because we want to call a witness at trial. We have a very different discovery obligation than the state. Ours is completely different. And I think that governs some of the discovery in this case and much of what we're talking about right now.
Okay. Thank you. I have no further questions, Your Honor.
Yes. The report, FDLE report that we received on February 22nd, 2013, who did that come from?
Who authored the report?
No? How did we get it?
You know, I'm not completely clear on that. I think it was handed to us, probably in electronic format, prior to a hearing that was scheduled later that day.
Did that come from the state attorney's office?
Yes.
And if what Mr. Krebo says is true, that was forwarded to us as a report from FDLE that was significantly inaccurate based on what Mr. Krudos testified to. Would that be correct?
Yes, substantially, significantly.
It was approximately a month before that Mr. De La Rionda has said to Mr. Krudbos, don't worry about it, FDLE will do another report. Is that the testimony that you heard?
Yes, that's the sequence.
There was a question of whether or not we had forwarded certain records or reports. I want to clear that up because it was I who authored the actual response. But in addition to the paper that you were shown, had we forwarded to the state a thumb drive that had upon it all of the reports referenced as extraction reports in that discovery?
Yes. The submission, the discovery exhibit, the pleading isn't the evidence. It's sort of a guide. It sort of identifies generally the actual physical product, if you will, or whether it's an interview transcript or photograph or a data extraction. And in this instance, all of the information was compiled on a thumb drive.
So we actually gave him the actual reports that our expert created, did we not?
The extraction reports, and then some,
Yes.
actually, a lot
We
more
did-
than just that.
We did not, as was suggested in his question, say, here's some reports, go back to the bin file and find it yourself, did we?
No.
Aside, for example, aside from pushing the create report button on Cellbrite, has Mr. Brenton prepared any other report?
The last report I'm aware of that he prepared was a couple of days ago when we got it. And before that, the last one that I knew of was basically a reprint, and that was February 21st or 22nd.
How long are you aware of how long it took Mr. Connor to do his analysis on the bin file when it was finally received at the end of February?
No, I don't. I know he had a substantial investment of time. And I can't really estimate his hours. I'm confident it's in excess of 25, but I don't know how much more than that.
Nothing further on.
Thank you, Lee Reedy.
No, Your Honor.
Thank you. Mr. Weston, you were going to take the speak. Any other witnesses from
I'd like to call Mr. Delarianda, Your Honor.
No, I'm not going to subject myself to it. I don't think it's a problem.
I have-
I would object to it.
We have two matters here, Your Honor. One,
Let me just say this as an aside. The court's intention for setting aside today and tomorrow was to conduct a Friday hearing over expert testimony. It is now 2:27, and we have yet to get to that hearing. What the defense is seeking in this motion we've been hearing since 9 a.m. is for monetary sanctions, which are easily taken up post-trial. The documents you already have, and in your motion and the testimony of Mr. West, you're seeking monetary damages. I think that the court's time on this issue is better taken up, as I said, post-trial, and that we need to get on to the Fry hearing. Because at this rate, we won't get that completed before we start the trial on Monday. It is this court's intention to do so. So I am going to suspend the rest of this hearing until post-trial, and I would like to start the Fry hearing. Do you need a few minutes to get ready to get your experts online to do that?
may I respond, Your Honor?
Of course.
We are seeking not only the monetary damages, but I believe that you should inquire as to Mr. Delarianda for this purpose. If in fact, and I think the evidence is certainly clear enough for the inquiry, and our request, our motion, was not just for sanctions, it was for a judicial inquiry. Because if in fact Mr. Delarianda sat here and said what he said to you a couple of weeks ago, and you interpret that to be an untruth, then that's direct criminal contempt.
Okay, and that could be done post-trial also, is my point. You're not seeking to have a witness excluded from testifying. You're not seeking to have evidence excluded. So those other sanctions that you're requesting can be done post-trial. And I think, again, the court's time is better used at this juncture going forward with the Fry hearing. My understanding is that there are several expert witnesses who are waiting to testify, and I would like to begin with that. So I will give you a 10-minute recess, and let's get those witnesses up. The court will continue this hearing post-trial. Court is in recess. technical difficulties worked out. So this is,
Yes, Your Honor.
okay, Mr. Manti, we're here on the prior hearing, and you go first.
Thank you, Your Honor. I think there were just a couple matters Mr. West and I wanted to address with Your Honor beforehand. I know we had filed a proposed stipulation with the court regarding the notaries. I don't know that the court's decided on that matter, but you'd instruct us to have notaries available to swear in their witnesses. If the court wants to have that done still, I have notaries on standby for my witnesses. If the court is content with signing that stipulation, I will excuse them.
Yes, it's fine.
Thank you, Your Honor. Secondly, Mr. West and I have had discussions. There is a witness that the defense intended to call, Dr. Nakasone, who, due to the nature of his job and his employment, has to testify today. And I don't know at this point whether they wish to ensure that he testifies today by calling him now or how they wish to approach that, but we wanted to make that, Your Honor, aware of that at this point.
Okay, so there's no objection from the state for calling him out of order.
None at all, Your Honor.
Okay, when is it that you want him available today to testify?
You know, I think it makes the most sense to have him take the stand now.
And is he here personally? Or?
He is, yes, he's here. Yes, let's do that. We'll call Dr. Hirotaka Nakasone. Your Honor, was Dr. Nakasone's report one of the reports that the court received?
I have not received any reports from the defense.
So let me provide this report for the court's reference. It'll help things move along.
Is this a comment for me to write on?
Yes.
Okay, thank you.
Do you solemnly swear affirm that your testimony is proceeding to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I have a moment? Just a couple of housekeeping matters. I'd like to introduce the court to Michael Piniella. Mr. Piniella is a recent law school grad and will be assisting with some of the electronic or the technical stuff with the court's permission.
Thank you. Nice to meet you.
And because we are connected here with technology, there may be other persons listening or viewing the testimony that will help then expedite their testimony later, other experts and such. And I believe there is one expert currently able to hear these proceedings.
I'm sorry. Does that mean that there are witnesses who are going to testify who are listening to this witness's testimony?
Yes, that's right.
Okay, they're experts?
Yes.
Only experts that are going to testify listening to this testimony?
Yes. Good afternoon.
Good afternoon.
Would you please introduce yourself to the court, please?
My name is Hirotaka Nakasone, Nakasone. That's my last name.
And what is your business or occupation?
I'm currently assigned to the Operational Technology Division of the Federal Bureau of Investigation as a senior audio electronics engineer. stationed at the Quantico, Virginia.
How long have you held your current position?
My current position starts in 2009 as a senior scientist, doing pretty much about the guidance and advice for the FBI in terms of the voice biometrics. But prior to that, I was in a similar position with the lower assignment. But I've been working for the Bureau as a full-time employee for about 17 years.
And what is your background and training that qualifies you in the area for which you're employed with the FBI?
My qualification to do a voice comparison and other forensic and audio examination was due to the training that I was provided by the FBI's program. And I was qualified to do such examinations back in 1994. But prior to that, I was also working for Los Angeles County Sheriff Department as a voice specialist for about 7 years. And my doctoral degree was written in the area of speaker recognition as well in 1984.
And what degree do you hold, and from where?
My most recent one is the PhD in speech science from Michigan State University. That was awarded to me in 1984. And prior to that, I received a master's degree from the same university. Same, Michigan State University in East Lansing, Michigan. That was 1979. And I have two bachelor's degrees, one in psychology that I received from University of South Carolina in 76. I have a bachelor's degree in English from University of Ryukyu, that is in Okinawa, Japan, back in 1972.
For the court reporter, that's RYUKYUS. Is that correct, Doctor?
Yes, that's correct.
Since being awarded your PhD in 1984, have you spent substantially your entire career in the speech sciences?
Yes, I have, Mr. West. In 1985, I took a job with LA County Sheriff Department, and my first assignment was to carry out scientific development research on speaker recognition that was funded by National Institute of Justice and also sponsored by a few industries, including Sheriff Department itself in Los Angeles County.
Since at least 1985, have you been aware of the state of the art in speech sciences insofar as speaker recognition is concerned?
I think I was following quite closely state of the art by collaborating with my colleagues across the different agencies, and also attending a variety of technical conferences in U.S. and also outside the U.S.
Are you a member of any professional associations that... I'm sorry, we may have had a loss of signal here. Maybe take just a moment. It's okay. Just be sure. Doctor, I was asking you about your professional associations and organizations of which you are a member that relate to speech sciences.
Yes, there are a few. The first one is the Acoustic Society of America. I'm a member of that association. And I'm a member of the International Association for Identification. And I'm a member of the Institute of electrical, electronics, and engineers. And I'm also a member of the American Academy of Forensic Sciences.
Have you had occasion to publish in the area of speech sciences?
Yes, I've been publishing pretty much, annually, and my publication annually. Yeah, I published in Acoustic Society of America in the multimedia digital sections. I have published in the Interspeech. I have published in the Institute of Electronics Engineer, and I also published in the International Association for Identifications Journal. And I published some others in different, technical professions, including very specific, proceedings in the automatic speaker recognition, known as a automatic speaker recognition odyssey, that has been held internationally since 1994. I've been published in that forum a few times.
Dr. Nakasone, have you listed some of your presentations and publications in a curriculum vitae dated June 3rd, 2013?
Yes, I have.
May I approach the witness, Your Honor? Let me show this to you and see if this is the document.
Yes, I do recall that I updated this CV and then sent to you last week.
Your Honor,
No, this
may I
week.
provide
I'm
a copy
sorry.
with to the court?
Yeah, do you want to mark this as an exhibit for identification? Have you seen a copy?
Actually, I have it of this one, so I'd like to see it, but
Oh, of course, I'm sorry.
I don't, that aside, I don't have an objection to it.
Are you seeking to have it admitted into evidence or just for identification?
Let's mark it for admission.
Okay, no objection from the state?
No, Your Honor.
Okay.
In fact, I believe that I have provided virtually identical documents for a number of experts in this case, and if it's okay with counsel, I'd move to have those admitted all at the same time. Just take care of it all right now.
Well, we have to have the court get those, so why don't we wait one at a time? So Dr. Nakasone's CV will be admitted for this hearing as defense exhibit number 1.
Dr. Nakasone, in your professional work with the FBI and with your professional associations, do you make it a point to be current in the state of the art of speaker recognition and speaker identification? I misspoke already. Correct me, please.
I am trying to interpret. You're asking me if I'm ready to offer my professional opinions about the current state of the speaker recognition technology based upon my professional experience and also based upon my interactions with the relevant, colleagues.
That's right.
You okay?
Yes.
This is my opinion based upon my experience dealing with the R&D.
Judge, has he been tendered as an expert in a particular field and accepted by the court before we get into testifying about an opinion?
No, but I don't think that that's necessary. Go ahead.
May the witness answer? Yes, you may continue.
In the past 10 years or so, it's a general consensus among scientists that speaker recognition technology, by using sophisticated mathematical algorithms, have grown remarkably to the point that we can say there is a reasonable reliability in the technology, and which must be followed by caution, though. Number two, the same group, in my judgment, agrees that technology is still fragile. It can break without warning if it's used by untrained or reckless users who really do not possess appropriate scientific background. So this fragility is second part of the community's consensus. And number three, that's the last one. There has been many voicings from scientific communities that we need to establish some sort of committees or scientific working group to establish strong guidelines for those who wants to practice this, and then try to understand the scientific foundations. So the number three, in sum, there is a consensus that we need to have very strong guidelines to make sure that if this new technology is used in a courtroom situation.
Are you a member of any working group whose task is to develop these guidelines?
Yes. There is a brand new scientific working group has just been established back in February this year, February 15. The name of the group is the Scientific Working Group for Forensic and Investigative Speaker Recognition Technology. And there are approximately 10 founding members. I am one of them. And there are a total of about 32 members carefully selected. And I am serving right now as a chairperson of that working group.
How does one become selected to be a member of this group?
The selection process took place about a year or so. It was, most of the members were selected very carefully based upon their track record in research, and then their track record of the integrity of the persons, and also their publications in the reputable technical journals.
And does this assembled group meet in order to develop the standards that you are mentioning here?
Yes, currently the meeting will be held twice a year. And in between, they are collaborating on constant basis to develop consensus documents about the guidelines, how the practitioners will do their jobs, and also trying to enforce the scientific foundations of this technology, and then also plan and design the training programs. Currently, this scientific working group is being co-sponsored by two major agencies. One is the National Institute of Standards and Technology. That's part of the Department of Commerce, and also sponsored by the Biometric Center of Excellence within the Federal Bureau of Investigations. The members were drawn from other federal agencies, industries, and academia.
Are the members of the committee recognized members within the speaker identification scientific community?
Yes, they are all.
And perhaps you could help us better understand, from your perspective, what the relevant scientific community is, and in the area of speaker identification.
Those individuals we selected known to have real good knowledge about the human speech behavior, and most of them have PhD degrees, either in computer science, speech science, or electronics engineers. And most of them have been so-called entrenched, deeply involved in the development of speaker recognition computer algorithms and most of them have been applying that, technologies into human voice data for research purpose and also for realistic applications for forensic or intelligence purposes.
Have several of the members of this working group effectively committed their professional careers to the area of speaker identification?
Most of them, yes, they are. Maybe a couple of decades or longer.
Let's turn to, well, let me clarify a couple of things. The National Institute of Standards and Technology, is that commonly referred to as NIST?
That's correct.
So if one were to use that acronym NIST, that's the entity that you're referring to?
Yes.
Is that the former National Bureau of Standards?
I believe so. Some years back, they changed the name.
And is one of the purposes of that organization to develop standards in scientific areas such as speaker identification?
They were more involved in encouraging the development of a speaker recognition technology by offering annual evaluation workshops in 1996. There's a program known as a NIST Speaker Recognition Evaluation Workshop. The last one was held back in December 2012. And usually they have this, workshop pretty much every year. If it's not, maybe, next year or so. So in my opinions, they have already done maybe 12 or 13 different, workshops. And participants in that workshops are those, research organizations throughout the world. They receive, each participants will receive data prepared by NIST. And they will process that data against the speaker recognition systems and send out scores, thousands of scores to the NIST. And NIST will evaluate how each system is doing. But I want to make sure this evaluation is not really open to public. It's only allocated or provided to those who are developing this system, and no publications of the performance results are allowed.
If I understand generally what you're saying is the NIST evaluation program allows people or laboratories to submit their voice identification method for evaluation based upon a set of samples that NIST decides on.
That's correct.
And then they evaluate the effectiveness and the reliability of the particular method?
That is correct. And then there are a few metrics that it needs to use all the time. The one is known as a equal error rate, and another one is the detection cost. Those, performance metrics has really nothing to do with the application aspect. It's simply designed to measure basic, accuracy or precision of the systems. Those numbers. The numbers that NIST will provide have little to do with the actual applications.
Is this evaluation of methods designed for forensic application?
Mostly not. There was one particular session back in 2001 under the name of forensic sessions within this NIST evaluation. But that's not the primary focus of the NIST evaluation program.
If someone participates in this program and receives a certain score, the rules prohibit them from using it in marketing or advertising. Is that what you meant?
Yes, that's well-known restrictions imposed by the NIST to every participants. They call it honor system.
Sure. Let's shift more specifically to the work that you do at the FBI. Would you describe what your responsibilities are in terms of management and casework?
My current status is senior level. And the senior level means that I do have a responsibility to the upper management. I report to the Operational Technology Division directly, and my function is about the advisory in nature, anything related to speaker recognition technology, forensic audio technology, or development of voice biometrics technology. And I work with other federal agencies for collaboration purpose, and I will also work with my counterparts in different divisions. As a collateral duty, I also provide a forensic analysis, and that's why the report that I have written is coming out of the forensic audio, video, and image analysis unit. I am still linked to that unit because of my collateral duty to do forensic examinations.
Do you then still participate directly in forensic examinations of speaker identification?
Yes, I do. In terms of doing my own cases, and I'm also involved in supervisory functions of other voice comparison examiners and training of newcoming employees.
There are other voice identification. Let me ask you, first of all, for the right word, to describe the work of trying to identify an unknown voice on a recording. Is that generally known as voice identification?
Yes, but in terms of specific terminology we use is voice comparison. The examination to be conducted for the comparison purposes is known as a voice comparison examination. And the individuals who are qualified and certified by the FBI to conduct voice comparison is known as a voice comparison examiner.
When you say voice comparison, are you referring to comparing one voice against another?
That is correct. Usually, we receive voices from known individuals, along with voices coming from incriminating recordings, and this is called unknown voice. And these were sent to this unit, and the minute the case is accepted, the qualified voice comparison examiner would be assigned to take the case.
Are there other qualified voice examiners in your section at the FBI?
Yes, currently there are 2 other qualified examiners and a few in the queue finishing up the training right now.
An individual that's been identified in one of the papers in the case is Kenneth Marr. Does he work with you?
Yes, Mr. Marr is the supervisor of that unit in the audio sections. He is qualified to do audio enhancement, signal analysis, and audio authenticity. However, he has not been qualified to do voice comparison yet at the time of this particular case coming into our program. Since he was not qualified to do voice comparison yet, it was assigned to me.
So, just, you did the voice comparison work in this case, in the George Zimmerman case.
Yes, I did.
Do you have assistants and other qualified voice experts to help in a case where you might enlist their services for some aspect of the analysis?
Usually we have a people or employee whose status is technician. And technicians are trained to do most of the case works, but actual decisions will be made by the qualified examiners. In my case, I didn't have technicians. Instead, I had another qualified examiner, and we pretty much worked together.
Sometimes does your analysis involve blind testing?
That approach is taken a lot of time for the safety guard. The most, often, I mean, when we have, signal analysis, it happens in this case too, to determine what's being said in certain designated area. We go into a signal analysis. And if the computer cannot decipher what's being said, then we'll depend upon human examiners. Usually, we request several examiners, and we'll make sure no two examiners are talking to each other about what's being the first one heard. We call them blind test.
Why would it?
We play back this designated area, and then the individual will listen to it very carefully under the professional headphones.
Why would it be important that one of the examiners not talk to the other about what they heard?
It's because of bias factor, because there is a tendency. It's not examiner tendency, it's kind of a human nature. Because of this human nature of linguistic fitting, if they listen to something very noisy and ambiguous, recording, there's a tendency that each human being try to hear and eventually comes up with some random assessment. And if the signal is reasonably clear, there are always more than two people can hear the same thing. So to avoid this bias factor, we'll make sure nobody will talk to anybody, so that their opinions will be completely independent.
Is this notion of suggestibility recognized in the community?
Yes, that's one of the major factors.
So if you're asking someone to tell you what they hear being said, you would not want them to know in advance what you think was being said.
That is correct. We want to avoid that.
And would you pay special attention to be sure that artifacts or noise wasn't misinterpreted as speech?
That examination can happen now and then, but usually we can say whether it's human speech or transient noise happening by something else.
Is the risk of that occurring greater if the level is low or the recording particularly noisy?
That is correct, especially the signal or voice we want to hear is completely buried in the noise. We have, tendency to do, linguistic fitting. That depends upon the individual experience. But the trained examiners are fully aware of this phenomena, and they are trained not to offer guesswork.
And that's part of the reason why you would do a blind examination?
Yes, sir.
If we might talk a little more about the voice comparison community, the scientific community. Are there various methodologies that are employed in the scientific community to attempt voice comparison analysis?
Yes, historically, there were a few. The most well-known methodology is spectrographic voice comparisons. It's been available since early 1960. It's a little practiced a little over half century. And another one is the phonetic method of a speaker comparison. And yet another one, which is kind of very important, the oral method of voice comparison. This means that the listening will be applied to determine whether two voice samples under the examination were produced by the same individual or by different individuals. And spectrographic comparison started with lots of controversy. It remained to be controversy. And even up to this point, it's still very much a controversy because of the inconclusive nature of the technology. The FBI actually has adopted this spectrographic comparison for many, many, many years. But under the very strict policy to produce any kind of results of voice comparison based upon the spectrographic comparison should be offered only as investigative guidance, meaning report cannot be introduced in the courtroom, or the examiner produced that report cannot go to court and testify.
That's the official position of the FBI in 2013?
It still remains within the FBI.
Are you trained in spectrograph?
Yes, I have, and I still can do it. But the FBI made a transition about a year ago, back in May of 2012, from old spectrographic technology to automatic speaker recognition, combined with examiner listening method.
Just one more moment about the spectrogram. Spectrograph is the technique. Is that what has been called by some a voice print?
Unfortunately, yes.
Is
some
that
people refer it to voice prints, but these days, the word voice prints means other things too. I've heard local police officer mention that they have a voice prints. He was referring to voice samples. But in specific questions you posed me, in the past, there was this voice prints were referring to spectrograms.
Was it once considered or argued that a human voice was unique and that an individual could be identified as against an unknown voice by virtue of the spectrogram?
There were many propositions, made in the past, especially when this spectrographic technique was introduced in 1962. The gentleman called that, the everybody's voice is unique, and the spectrographic technique is infallible. But by subsequent, studies and research, we found that's not the case. Everybody has, no one can speak in the same way twice. When they speak, speech comes out slightly different. And that difference is known as a intra-speaker variability. On the other hand, two people can produce differences. And that difference is known as a inter-speaker variability. It's an inter versus intra-speaker variabilities. So now getting back to this uniqueness of the human speech, it's not really cut and dry, categorical differences. Instead, the scientist right now is trying to figure out what would be the margin or sections interacting between intra-speaker variability and inter-speaker variabilities. The distinction of the individual is more like probability theories. We can call, okay, if I have two of these samples, my results can be rendered by saying it is likely to be produced by two different people, or it is likely to be produced by the same individuals. It's more stochastic or more probabilistic. It's not cut and dry that the human speech is completely unique.
Did you say that the human voice is variable enough that if one were to say the same word over and over, it would be different scientifically?
There are always differences, yes. Well, because each time when I say something, the minute the energy of my speech exits my voice, it goes through the air and it hit diaphragm or the microphone. So if something is different in the air, that will produce variations in my speech, and also the articulation. Human articulation is not really precise. Every time there is a slight difference. That's the variation happening in the normal speech, but variation also can happen because of the emotional status, different emotional status I'm in. So when we talk about the speaker recognition technologies, scientific communities are fully aware we have to address many factors that will impact negatively upon their performance. The first one is the intrinsic variations. Intrinsic variation has something to do with speaker himself, his language background, cultural background, and his state of mind, state of emotions, and also different speaking purposes. My talk to you right now in the courtroom may be different from the way I talk to my wife at home. That's the speaking style thing, and also the condition, health condition of the individuals may also affect the individual voice quality. That's all part of the intrinsic variabilities. And there's extrinsic variabilities. That's the most serious one. My voice is now heard by you, by everybody, through acoustic transmissions. There's no electronic devices involved. But once it hits this microphone and recorded by something else, then it has some effect on my voice. That's why, you sort of experience, you're talking to your colleagues in the office, live, face-to-face. And this person's voice may be heard slightly different when you talk to him on the landline telephone or on the cell phones. These are the factors affecting individuals' voice. And then the room acoustics. Depending upon where you are, your voice is always, contaminated or superimposed by, environmental noise. Mm-hmm. Say this in a courtroom, it's quiet, actually. It's very good. Very minor reverberations, but the reverberation affects the human voice. And then a compression of the modern day, electronics technology also affects human voice.
What do you mean by compression?
The compression is it's a mathematical way of reducing amount of data to transmit in exchange of the speed. Say like the original cell phone type in the past, they had a very poor compression scheme. So that's why it was very difficult to understand now and then.
You're speaking of cell phones?
When you're speaking, cheap type of a compression scheme, it's very difficult to hear. And then satellite transmission is also very poor. And the MP3, I'm not sure if you're familiar with it, it's an MP3, that's very popular compression scheme. If they use a very, lossy type of compression scheme, we sort of stop, appreciating musical experience because so much of the information is gone.
Is compression a serious concern or a variable that you would consider in analyzing a cell phone transmission that was recorded?
In the past, that was the case, but these days, I think a compression scheme is improving, but we are aware if we do not know what specific one was used, probably the important information about the identity of the individual may be gone. It may carry, it's designed to carry speech information more so than to carry information about the speaker himself.
I'm sorry, I don't follow the difference. Speech information, I take it to mean what's being said and whether it can be understood by the person on the other end. What do you mean by the speaker identification?
When we speak, our speech carries a lot of information. The predominant information carried by our speech is a speech content, phonetic content, so that the listener can understand. But as a side effect, it also carries uniqueness about individuals. But that's not the primary purpose of the human speech. So speech carries content of speech and a little bit about the speaker himself. And then thirdly, speech also carries information about the environment.
You mean the surroundings of the speaker?
Yes.
Are you talking about noise?
Noise, traffic noise, room noise, reverberations, this type of things.
That may somehow obscure or affect the ability to evaluate the recording?
Depends upon the quality of the overall recordings.
Mm-hmm. Would the distance from the speaker to the recording device also come into play?
Yes. Usually when the speaker is off microphone, 1, 2, or 3 meters away, then human speech starts, getting some distortion or interference. We may be able to hear everything pretty much he said, but that speech starts losing critical information about individual. Distance, we call the party problems. Distance affects the performance of speaker recognition a lot.
A few moments ago, I was asking about the methodologies that are used in speaker comparison. You talked about spectrogram or spectrograph, and I take it to mean that's disfavored now and no longer used by the FBI.
So it doesn't Jack A, this characterizes B, he's leaving.
That's the next bit. Go ahead.
Did you understand my question?
Yes, I did. The spectrographic technique sort of run out of time. to prove its utility. And it has a great, asset in showing human speech in a visible way to, scientists. But it stops there. Interpretation of what's being displayed on the spectrograms now depends upon the ability of the observer. And the observer needs to have thorough training in the phonetics and other disciplines related to human speech productions. It's a lengthy training process. The trained phoneticians or speech scientists, they can look at the displayed spectrograms and then try to understand what's being said. They can say it. But when it comes to the voice comparison, the interpretation is completely subjective. And that subjectivity rendered ineffective, opportunity for scientists to study meaningful scientific, assessment, validation of the technology. It's been a little over half century now. Sporadically, some research were conducted, but I have never seen any rigorous research produced ever since 1972. When primary research was conducted by Michigan State University and then Michigan State Police Department. The research was sponsored by DOJ and published in 1972. That was the last major research project to my knowledge.
Let's talk about the other methods, the other approaches. You mentioned automated speaker recognition or computer software speaker recognition. Is that generally right?
Yes. It can be referred to any of those names.
Okay. What is that method and how is it used?
There are a few most basic fundamental technique is known as a Gaussian mixture model of the speaker recognitions. That Gaussian mixture model is completely mathematical.
What mixture?
Gaussian, okay, G-A-U-S-S-I-A-N. Thank you, Your Honor. I'm sorry, apologize. And mixture, like a mixture model. And that's called usually by GMM. And GMM, well, it has some history, but in 1994, many scientists started using it. And basically...
Stopped using it?
Began. And because GMM, I think we have seen tenfold rate of improvement of the speaker recognition technology. Basically, that technology breaks down human speech into thousands of components and then quantify human speech by models, mathematical models. And this particular model is designed to work on random texts, not paying attention to whatever the words were said. It's called text-independent approach, and that's what GMM really means. And GMM takes speech samples, say 1 minute, 2 minutes, or 3 minutes, and go through multiple, transformations. First, spectrographic transformation. From spectrogram domain, it will go into another, transformations and extract the speech features. And those features are utilized to create a model. or mathematical model of the speaker. And that has been proven to be quite effective. But a few years later, a new one came out. That is known as a SVM. That's a Sam, Victor, Mary. And it stands for Support Vector Machine. Then 2010, when NIST had speaker recognition workshop in Czech Republic, new algorithm came about, and that's known as a iVector. And the iVector, as of today, is the most advanced, cutting-edge speaker recognition algorithms. And these technologies are evaluated against very typical, reasonable, speech samples recorded through telephone lines, and also utilized to measure performance against reasonably spoken natural voices.
Is this different than me trying to make an airline reservation over the phone and the computer recognizing a voice on the other end, or is it similar?
Similar. Your phone call to airline might be one of those test data that NIST might be applying to test against the speaker recognition algorithms.
But of course, the airline doesn't care who I am. They just want to be able to understand what I'm saying, I take it.
That's called a speech recognition domain. Speech recognition technology is designed to understand or recognize what's being spoken. The system which is designed to detect what's being spoken is not necessarily designed to determine who you are, who the speaker is, because there's a primary difference. When we do speaker recognition, system must have templates or models already existing in the system, and compare new coming voices, and create a model immediately, and compare against the existing gallery of models. So if the system doesn't have any library of designated customers already stored in the data bank, there will be no speaker recognition.
Does the speaker recognition algorithm or software that you're talking about encompass the full range of human speech, including the detail that you were talking about that's often lost on a cell phone?
I'd like to answer your question this way. The all-encompassing terminology to describe everything what you said is a human language technology. And underneath of the human language technology, we have speech recognition technology, speaker recognition technology, language recognition technology, and content analysis technology, and machine translations, and then speech-to-text conversion technologies. But today, I think we were sort of focusing on speaker recognition technology only.
Yes, thank you. Is there anything else regarding the computerized approach to speaker recognition that would help the court understand that approach to speaker identification?
As of today, we have a few speaker recognition computer or software. And when we feed, say, 2 voice samples into this computer, as long as these 2 are good enough for us to do analysis, say reasonable speech quality, and then long enough, 30 seconds or so, the computer go ahead and then compute and spits out the score known as a log likelihood ratio. Log likelihood ratio. And that's the output score coming out from the machine. And then we take that numbers and then compare that against the threshold table we have at the laboratory. And then if the number is, in a certain region, we can either call it a match, or if the threshold is a little lower, then we call it probable match. And if it's in between, we have to issue inconclusive. And then goes into a probable no match and a no match. And this, results of, 5 scales stay there. And then meanwhile, the examiner will be conducting perceptual comparisons. And he will come up with the similar scales of the results. So the two are combined.
When you call it a match, does that mean like a fingerprint, that's the person?
Yes.
And that's based upon the software that you just ran?
Combined with human examiner's listening ability.
I'm sorry, I was making that a two-part question. So we're talking about the computer-aided recognition now. When you use the computer to analyze the speech, and the result is a number, is that right?
That's correct.
And is that from 0 to 100?
No. It's pretty much minus infinity to plus infinity.
Pretty big range.
Because the number is ratio of two numbers. The numerator of that ratio is a probability of that the sample was generated by the target speaker we are analyzing. That's a numerator. It's a probability, 0 to 1. And in the denominator, we have another probability which says the sample we are given was generated by all other people, but not by these particular individuals. And that number also varies from 0 to 1. And then we take logarithm of that. If we take log, and then now we'll be dealing with negative numbers as well.
Once you've processed the speech and have a number, does that end your analysis? You mentioned something about then the examiner looks at that orally.
Yes, we have to compare that numbers to the tables. And that table contains the threshold of a decision. And that table was created by empirically by assessing the performance of any system we use against the assembled database we have at the FBI. Those databases are designed to be good representation of forensic conditions. Because depending upon the quality of the voice and also whether it was recorded by a good studio microphone or telephone, landline telephone or cell phones, and also depending upon what language being spoken, all those environment changes the region of the interpretation of the scores for match or no match.
Lots of variables?
Yes.
And
we are using 14 different conditions as of today. But it's not that number 14 is arbitrary numbers. In reality, it could be much, much bigger numbers.
Once you've processed the speech with the computer software, what do you do in your analysis next?
Next step would be the fusion of the scores coming from human examiner with scores coming from computer. And say like the audio examiner, voice comparison examiner comes up with match, whereas computer says it's inconclusive, or if the computer says match also, only at that time examiner is allowed to render a final conclusion of a match. But if the computer comes up with negative match or no match, examiner is forced to say inconclusive. So there are a variety of rules to dictate what conclusions can be issued by the examiner as a final conclusions.
You don't make any match based solely on the computer software?
That's correct.
It's always reviewed by a listener, a trained listener?
Right.
And when you say match, does that mean that the examiner, at least from the FBI's perspective, would be able to testify in court?
No, sir. Right now, we are still under the policy guidelines. We can issue the report only as an investigative guidance. We do not go to court and testify to the results of analysis we did. We have about a couple of years. That's possibility, but we have a long way to go before the system is ready to be rendered as opinions in the courtroom.
Let me take you back to a comment that you made in the process of preparing the speech for analysis by the computer. You made a reference to the type of speech or the length of speech.
Yes, sir.
Is there some recorded speech that may be submitted for analysis that's not suitable for analysis?
Yes, that's something we do the first. There are 3 steps. The first step is called quality check 1. When we do quality check 1, we are listening to the audio. We are checking naturalness of the speech. We are checking probable compression effects. And we are checking the probable effects of intoxication, effects of alcohol, and unusual degree of stress, whether the person is too sad, too subdued, or agitated psychologically. If there is anything which deviates from normal speech, we tend to issue non-doable. It doesn't meet our requirement. And also we check the overall duration of the speech samples. Say like a conversation which lasts 1 minute is submitted to us. And in that conversation, say person A is a target. So we go in there and separate segments spoken by A only and concatenate and measure the speech samples duration. And if that duration is, according to our current rule, if it's less than 16 seconds,
60 or
16 seconds, the examiner is bound to say non-doable. He has to terminate examination at that point, and then advise.
Let me clarify that.
Yeah.
You may have a speech sample that's a lot longer than the amount of speech that you determine can be used in the analysis. Once you've filtered out, let me say it a different way or better, I hope. You use the example, you might have a minute of speech to evaluate, but by the time you isolate the speech that you can analyze, it may be considerably less than the minute.
Yes, that happens all the time.
And that, do I understand that if the speech that you determine can be analyzed, under your guidelines, that speech has to be at least 16 seconds long?
That's correct. There's a buffer zone. If it's 16, we have to approach very carefully using discretion of the examiner. But if it's less than 14 seconds, he has to determine that the speech data is not useful for the comparison. And he is mandated to advise the sending agencies to send another voice samples, longer voice samples, or advise them that FBI cannot do anything with that voice samples. We wouldn't proceed to a comparison at that point.
And that means after you've already eliminated speech that might be too emotional or as a result of intoxication or something else that would make it inappropriate?
Usually when there's evidence of intoxication or psychological strain, it's pretty much throughout the entire file, usually. So we sort of terminate examination at that time.
What is the objective of the 16 seconds? Why, if you know, would that amount of time be considered the least amount of time?
It's dependent upon our empirical laboratory experimentations. That experiment, I conducted that experiment several years ago, and I published the results at the international conference at I think it was in Spain. And also there are other corroborating results issued by MIT, Lincoln Laboratories and researchers. We seem to have some agreement on this, 15 or 16 seconds, area. It has the principle. A lot of people agrees that it may take, for a while before human speech reaches reasonable balancing or phonetically balanced speech samples. The speech input to speaker recognition technology by software requires it to be phonetically well balanced.
Would you explain what you mean by that, phonetically well balanced?
For example, American English has about 44 different sounds, 44 different phonemes. Say when I say hello, maybe that may has a H, E, L, and O, 4 phonemes. But to cover all those 44 different phonemes, roughly speaking, it takes about 20 or 30 seconds. And if the speech input to the recognition system is not well balanced, it will give meaningless results.
Is that a rule of thumb that's used by any method? You've talked about maybe 3 different approaches, spectrograph, and then the computer-aided, and then you also talked about the listening, the oral, critical listening approach.
There are different criteria. This number was derived from computer domain, but for spectrographic domain, we have some numbers. We need at least 20 well-spoken words to do spectrographic comparisons. Mm-hmm. And maybe 2 of those numbers, or combination of the 2, in my opinion, should be applicable to listening speaker recognition as well. At least in the FBI's audio laboratory, we apply same 16 seconds rules to both automatic recognition and also to perceptual comparisons by examiner.
When you use the term perceptual comparisons, that's the listening approach you're talking about?
That is correct.
Are you and those examiners at the FBI lab familiar with all of those approaches to speaker identification?
Yes, we are.
And do you employ them in the laboratory?
Yes, that's correct. These examinations are being done under strict guidelines under the standard operating procedures, we have those, formalized procedures that were established under the ASCLD, the American Society of Crime Lab Directors. The laboratory I'm talking about is accredited by this National Accreditation Board, by ASCLD.
Is that certifying entity able to certify laboratories in the private sector?
Both. It can accredit federal agencies, crime lab, state, local, and also private sectors, if they are willing to do it.
If a private lab wants to be accredited, they would have to submit to the protocol required by the certifying entity?
Yes, they can.
Let's talk more specifically, if we might, about the work that was done by your lab in this case. And I believe that you testified earlier that you personally did the work insofar as speaker identification is concerned.
That's correct, sir.
Your Honor, I'm not sure if the court has heard the recording that is the subject of this testimony, and I'd like to play it with some help. Let me preface this, if I might. Dr. Nakasone, this recording may not be precisely the one that was submitted because it's been redacted of certain speaker identifiers in terms of name and such.
Understood.
Okay. So the court is aware, this recording is the product of a 911 call that is recorded and contains the subject of this witness's testimony, but it also contains a gunshot, just so the court's aware and the gallery as well.
I just asked, do we have the audio up? It doesn't seem to be. Okay, it's not playing on our end, and we're in the same boat. Yeah, I've got it plugged into the cord.
Some water. Yeah, first witness.
All right, thanks. Yeah, I needed it.
All right, let's try it once more and just make sure that it's good on your end because it's playing on ours. All right, this time we're going to have to just play it off of the laptop right here, okay?
Do you need police, fire, medical? Maybe both. I'm not sure. There's just someone screaming outside. Okay, what's the address that they're near? Is this in the Twin Lakes homes in Sanford? Yes. Okay. And is it a male or female? It sounds like a male. Okay, and you don't know why? I don't know why. I think they're yelling help, but I don't know. Just send someone quick. Please stop. Okay. Does he look hurt to you? I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him. So you think he's yelling help? Yes. All right. What is your serial number?
Dr. Nakasone, does that appear to be substantially the same recording that was submitted to the FBI lab for analysis as to speaker identification?
Yes.
And did you evaluate this recording for suitability for further analysis?
That's correct.
Would you tell the court what steps you took to evaluate this recording?
We received the CDR and transferred all the audio files we received from Tampa FBI field office, specifically coming from Special Agent Maeski from Orlando Regional Agency, and we transferred all those files in the computer and made sure that data all there. And but since we were asked to do an enhancement on all those files, we did. And then that was March 23rd. And one day later, we also telephonically requested another request from Tampa office to do voice comparison. So therefore, well, basically, we started enhancing all those audio files. And then I singled out one particular recording. That was the same file which contains, the recording information we've just heard. We tried to enhance the recordings to make so that there will be, better intelligibility, of the background. We did.
What's the process for that? Is it through computer assistance?
Pretty much everything is computer assisted. A variety of different softwares being utilized, either commercially available software or a few law enforcement sensitive proprietary softwares that are available to the FBI.
And the purpose of using that software at this stage is what?
Yes, the purpose was simply make everything audible. But sometime this attempt would prove ineffective because of the nature of the audio coming in from a far distance. So in this particular case, we did not take chance. So we analyzed both direct submission, the original recording, and also enhanced versions. And by using the program we have, we listened through the entire recording. I think entire recording something was maybe a little over 45 seconds or so. And then in that, there was a time window during which time this screaming voice lasted, something like 18 seconds. And then I went through every segment of that utterance very carefully and eliminated when the screaming voice was masked or stepped on or imposed by the 911 caller or by 911 operators. And then there was remaining only a little less than 3 seconds of segments where I could hear relatively isolated screaming voice.
The idea of eliminating the part of the recording that was masked or stepped on, is that necessary?
Yes, definitely. When we do voice comparison, we got to feed a pure segment that's only one individual is not talking. If stepped on by somebody else, we have to discard it. So in our judgment, there was a, say 3 second long screaming voice that we determined that screaming was not normal. It was pretty much uttered by someone who was facing probably imminent threat of death or something. Very difficult to analyze. And we also determined that by doing some spectral analysis for the purpose of signal analysis, we figured that the voice was outside normal range.
Why is that important to determine when you're assessing this, the level of emotion or stress?
We know the system cannot distinguish normal speech from abnormal speech or emotional high speech. So therefore, the system automatically assumes that's not, it assumes not, whatever you put in, system assumes and follows this principle of, garbage in, garbage out. And we want to make sure the input to the speaker recognition technology is a fair representation of normal human speech. And that screaming was not normal, natural speech. It was uttered by, a completely different anatomical or physiological condition of the individual who is going through tremendous duress. The pitch of the human can change depending upon the emotional status. And to make things worse, it's not just pitch which is changing. A lot of other articulating vocal musculatures, muscles, different muscle groups will be utilized to produce that kind of strenuous voice. And unfortunately, science is not here with us to tell all of those different, conditions apart.
Explain what you mean by that, please, that science is not here to make those distinctions.
We have just recently in the communities started paying attention to the performance or accuracy of the system, which can be affected by different, vocal effort involved in the human speech. And to the extent scientifically possible, we are barely able to produce under controlled environment that someone's voice has normal vocal effort, minimum vocal effort, or high vocal effort. And high vocal effort means that the individual is talking with lots of emphasis. And that can be produced experimentally by feeding him a loud noise through headphones. And the individual has to overcome that noise is coming, bombarded into his ear through headphones, and he starts speaking loud. Okay, that is the extent of the scientific communities right now can manipulate, and let alone trying to compare voice samples, which was taken from screaming voice. It's a little too far for us to address. And from my experience, what's going to happen to the output of the automatic approach will be, number comes out, but that number will be completely meaningless, confusing. It might mislead in the worst case. So scientific community is not really, I don't think anybody has a system right now which can compare short segment of screened voice against reasonable natural speech and then come up with correct answers. I doubt that very much at this point of time.
May I have one moment?
Thank you, Your Honor. Afternoon, Doctor.
Good afternoon, Mr. Monte.
Need a rest, need a break? You've been here a while. You good to keep going?
Sure, no problem.
Okay. As I understand it, there are three principal or traditional methods that have been employed to analyze speaker identification, and I think you went through those briefly as sometimes it's the computer software, the algorithms, and that sort of thing. Then there was the aural, and that's AURAL, the listening component. And then you also mentioned spectral analysis, right?
Correct.
None of those are new. None of those are novel. All of those are well documented throughout history.
That's correct.
And in fact, the FBI actually still uses all of those, although you only use some of them now for limited purposes.
That is correct.
And in fact, you personally, when you did your analysis in this case, employed all three of those methods to a degree.
To be specific, employed all those principles coming from those.
Okay.
We did not subject our data to automatic comparisons.
You wouldn't use any one of those exclusively to draw a specific conclusion in this case. You try to use all the tools at your disposal. Would that be fair to say?
Yes, that's correct.
All right. And when you got this submission, you were willing to go ahead and try to analyze it, right?
Yes, we did.
You didn't just listen to it once, throw up your hands, and say you couldn't do anything with it.
No.
All right. It was not immediately obvious to you what your conclusion might be, right?
Well, after a while, knowing that there was only 3 seconds,
After a while,
it became obvious.
Okay. But
Right.
that wasn't your immediate conclusion. Like I said, you actually analyzed it and spent some time looking at it.
Yes, it's part of the procedure because we have to document the reason for our termination of the exams. We have to be able to say that.
You took several days. Right?
Actually, yes.
All right. So you had no problem with the methodologies that you described, right?
I agree with you. That's
Okay.
correct.
Would you agree with me further that scientists such as yourself who apply the same methodologies sometimes come to different conclusions?
Happens quite often.
In fact, it's normal, right?
Unfortunately, yes.
Isn't it to a degree kind of necessary sometimes? Isn't that how science sort of evolves?
Yes, especially when technology is still evolving.
And in fact, I think you gave us an example in this case. You mentioned that it is only very recently that some in the community, and I guess including maybe yourself to a degree, have started to approach this matter of speaker identification a little differently in a new way and trying to set new standards and that sort of thing. So it's that new approach. That's what you're talking about, right?
Yes, that's correct.
And it's not the old methodology that is new and novel. It's this new approach, right?
I think this scientific working group for speaker, I think we plan to address all existing technologies.
And that group, you mentioned it's brand new. You've only had really one meeting, right?
One major one and one temporary one to establish officers.
The first one is just to sort of get together, and then you've actually had one real meeting, right?
That's correct.
Okay. And certainly there's been no rules or standards published by this group.
Not yet.
Okay. Now, there are scientific working groups. Yours is called what? SWIG Speaker? Is that the acronym?
Correct. Mm-hmm.
There are SWIG groups for a whole lot of disciplines, DNA being one of them, right?
Actually, there are 21 of them.
Okay. 21 working groups for
Forensic sciences.
forensic sciences.
And including new one, maybe 22. I'm sorry, I misspoke.
And the working group, the community itself, the scientific community, is a lot bigger than just the working group, right?
Yes.
Okay. And for example, to go back to my earlier example with the DNA working group, there are an awful lot of DNA scientists, but a very few are actually on the working group.
That's correct.
Okay. why isn't, let me just say it like this. The FBI standards may or may not actually be copied by any working group, right? For whatever discipline.
Well, that's the design. The FBI has its own, and this scientific working group is much larger than FBI entity.
Okay.
But the FBI is interested in promoting this kind of interagency activities.
Sure, and it's an ongoing dialogue.
That's
Would
correct.
that be fair? Okay. So it's important to get different inputs and different perspectives when you're deciding to try and come up with standards to govern sort of an entire field of study.
That's the intent, yes. That's why, so we have folks coming from, I'm sorry, can I?
Oh, absolutely.
This group is composed of people who are involved in the development of this automatic approach, and people who are involved in using phonetic approach of speaker recognition, and people who are involved. Only tiny number were involved in the spectrograph comparisons, but the majority of them would be involved in the computer approach, whether just algorithm or by using this phonetic approach of the automated speaker recognition. Idea is to include all existing technologies and methodologies.
And Doctor, I think without getting into a huge, great belaboring detail about it, there's a lot of variables that can affect how a recording is made, which will have an impact on whether or how you are able to analyze it.
That's absolutely correct.
And those are what I'll term, because I'm not an expert in this, sort of organic, meaning having to do with the speaker, the person speaking, and sometimes they're to do with the medium. In other words, whether it's a phone or a tape recorder microphone or anything like that, right?
That's correct.
And that's with every sample. Those effects and those variables are going to be encountered in every case, whether it's a forensic 911 screaming tape or something else, right?
Yes.
And in some cases, even accounting for all these variables, you are able to make identifications, right?
Yes.
And in some
By
cases,
assessing boundaries very carefully. There are only a few cases we can really do meaningful comparisons.
But you still try to do them because sometimes you can do it.
Correct.
All right. And as you said earlier, sometimes even scientists who look at something the same way come to different conclusions.
Yes, because of different background or different availability of different equipment.
Or even different abilities that the scientist has.
Well, not the scientists who may have the same philosophy possessed by the group that I'm in, probably opinion may tend to come in the same way, but I'm not surprised if the opinion different. And for that matter, I think it will be fair for me to mention to you in the courtroom. As part of our procedures, no decision can be rendered without second examiner's confirmation. That's our mandatory. This simply tells that the technology can make mistake.
You and I spoke over lunch, right?
Yes, sir.
Okay. We didn't meet face to face, though, did we?
Nope.
Okay. You recognize that I was the one talking to you?
I doubt.
Okay.
I didn't see your face.
Do you think a person who has only spoken to you but hasn't met you might be able to recognize the unique characteristics of your voice?
Okay, Mr. Mantin, I'm sorry, I lost.
Never mind. We talked about speaker identification. where you compare a known to an unknown and try to figure out if you can tell if it's the same person, right?
Right.
Is it also possible to listen to a known and an unknown and rule out that the known person made the unknown speak? You can do that too, right?
Well, it's not same thing. When we do listen, there are only three possible outcomes, and always there are three outcomes. One is, yes, indeed, these two voices are made by a person, or made by two different persons. And third one is you can always issue, I cannot tell.
You represent, I think you said that, you represent your decision as sort of not an absolute, but more of a percentage, is it? Just a estimation?
Probability.
So even if you were convinced that they were the same, you wouldn't say 100%, would you?
It doesn't happen.
Okay. But that is not unusual or a new or novel thing about any of these methodologies. That's just the way that this field expresses itself. Would that be right?
That is correct.
Okay.
It's a combination of the nature of the human speech production behavior. Maybe that would be the primary reason, I guess. Secondary would be just technology is still evolving. It may get better, but the primary reason would be on human side.
Okay. Thank you, Doctor. Judge, that's all the questions I have.
Thank you, Mr. West, and you agree, correct?
I'm not sure. The variables affecting human speech that you talked about here today that impact on your ability to reach a definitive opinion about speaker identification, is that those same variables also affect the analysis in each of the different approaches to speaker identification, to include the oral perceptual or the computer-assisted or even the spectrogram?
There might be some subtle difference, but I do believe majority of those factors will be applicable to all.
Is that why it's so important from your perspective to have at least a minimal amount or a minimum amount of appropriate speech for analysis?
Correct. Duration and quality together.
Do I understand that, of course, critical listening, that's the trained examiner listening for characteristics, that's been around, I guess, as long as people have had ears?
Yes, according to a certain book. It's been available since, Bible.
Sure. So you're talking about there a skill that someone can improve by training and experience?
Yes, training is going to be important, especially when speech sample goes through adverse conditions.
Mm-hmm.
Trained ear can tell whether it's true voice characteristic to the individual or characteristics created by different environments.
If I understood you correctly, that the computer-aided part is still a couple of years away from the FBI being able to use it in a forensic setting?
At least a couple of years. It may be a little longer, but certainly it's moving toward that. But as of today, it's still premature.
And that would still be in combination with a listener?
As of today, yes, but 2 years from now, I do not know. Human might be eliminated depending upon the application of the technology. If the application technology is not for courtroom use, say like data reductions in mass recording environment, maybe human doesn't have to take part in it. But when the system is utilized in the courtroom, I'm sure human component will be always there. Must be there.
Mr. Manti talked a little about whether the methodologies were established or whether they were new or novel. Can you speak to that, or should I ask a very specific question? Because I have one in mind.
Can you please ask your specific questions?
Yes. Are you aware of any methodology for voice identification that would produce a reliable result on the speech sample that you have in this case?
No, I'm not aware of any system as of today. And it will be, in my opinions, I wish I could have that kind of system myself, but I don't think it would be probable.
So if someone claimed then to be able to apply a method that you've talked about to the sample in this case, the application of that method to this small sample of screams, to do that would truly be new and novel.
I rather use different terminology. It's disturbing. I don't think, science is there and technology can handle that. If someone claims, I really have to just hold my experience, my knowledge about this field. It says it's not possible. So if someone claims, I really have to know exactly what he's doing, how he's doing. And then, in my opinions, it's a breakthrough in the scientific communities. It overshadows a lot of scientists' mind right now. I don't think there is such a system right now. At least I never seen one. And also judging from the fact that the NIST speaker recognition evaluation as of today has not even addressed the speech samples represented in this particular case. I'm talking screaming part. So lack of the evidence of existence of that kind of scientific endeavor tells me that it's not really feasible and not probable. And I'm sure that kind of claim not only disturb myself, but may disturb other scientists as well in the community.
Thank you. That's all I have.
Please, John.
So, doctor, when you're asked your opinion of this speech sample based upon the methodologies that you applied is that it is not usable for identification, right?
Yes.
What you just were asked by Mr. West was a little different question. What you were asked by him is, should anyone come up with some other methodology? You would question that other methodology, right?
If they claim they can handle this kind of voice qualities.
If, however, the claim is the methodology is the same, my opinion is simply different, that is exactly what it is. It is a difference of opinion as to the usability of the sample. Would I be right about that?
I think I'm confused a little bit.
And that's exactly the reason I got up here to ask you these questions.
Can you repeat that one?
Absolutely. There is a very big difference between suggesting that someone has invented a whole new methodology and suggesting that I simply have a different opinion as to whether the existing methodologies are able to produce a result from this particular sample in this particular case. Would you agree with me? Those are two very different things.
Yes, individual can have his own views about the capability of the methodologies. He's entitled.
That would be, as we've already talked about.
Yes.
It is not unusual for scientists to have very different views. In fact, there are people, you have in the past yourself had very different views from well-established other scientists. It's the nature of your business, isn't it?
Yes, everybody is entitled to his or her own opinions.
So again, if someone uses the same sort of methodologies, and I know you can't talk about the specific algorithms you used here, but if they apply various algorithms and critical listening and perhaps a form of spectro viewing, that is the same sort of methodologies that you use. In your opinion, is that this sample is not amenable to establish a result, right?
That's correct.
So your quarrel is not, as I said earlier, not necessarily with the methodologies. Your quarrel is with the opinion.
Yes.
Okay.
That's correct.
Thank you. Thank you, Your Honor.
Thank you. Anything further, Mr. West?
No, Your Honor, thank you.
Any other comments, any excuse?
Yes.
Thank you very much, Dr. Yours.
Thank you, Your Honor.
Yes.
Wondering if we could have a brief recess, Judge.
Well, I was just wondering where we were with this, because I did want to meet with council. It is 4:46. Should we break for the day and convene this tomorrow at 9 a.m.?
My witnesses are available to do that, yes.
Okay.
It makes sense, Your Honor, that was Mr. West's primary case. Quickly.
Yes.
Okay. So we'll be in recess until tomorrow at 9 a.m. on this matter, and we'd like to see council back in anyway to hear some of your client back in the
Oh, we would, Your Honor.
okay, and I'm having